Hello folks, back to the camera again. I am here to greet you all and say welcome to the channel. Got a bit of a tickle still. I think I've got a problem with my throat, as I always seem to have a tickle at the moment. But yes, let's forget me and let's talk about a few years back. I was illegally detained by a police constable support officer, a PCSO. And you've seen them, they walk around the streets and they've got on the badge on the back, police constable support officer. They're not the same as a policeman, although they think they are, some of them do. So he failed to identify, he failed to produce his designation card, which all PCSOs are obliged to carry at all times when acting on duty. Now, the registration card says designation card, not registration card. Designation card tells us what they've been authorised to do by the chief constable. So some have traffic duties, some have guarding duties, some do have the authority to arrest, but few of them do. So this PCSO, he assaulted me. Yes, he ran up behind me, shoved me into a brick wall by this large shop, which is closed, funny enough now, but it's going to be reopened as an athletic centre. But it was a large store, and after shoving me up against this brick wall, which did damage my shoulder, but nothing to complain about, and then he was physically holding my arm. You know, I resisted and he was struggling. He was a young man and he was struggling to sort of put it behind my back, but I wouldn't let him. When a patrol car arrived and two police officers, female and a male police officers, they got out the car and they told him to abscond, to run away, because they knew he was assaulting me. So before I could identify him, he'd run off. I had no identification from him. I had no sight of his designation card, and he'd gone. No name, no number, no designation card. And they deliberately instructed him to go. And they went, go, 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 to him. Now, the reason they gave me, this female and male police constables, was I was being stopped and detained, and my details, you know, name, address, age, date of birth, were demanded. And they also demanded that I empty my pockets. And they told me, come in, you can get into the back of the car. And I said, no. What am I being arrested for? Oh, at the moment you're not being arrested, you're just being detained while we carry out our investigations. Okay, what am I being investigated for? And they told me that the car park warden, where I'd parked my car across the road, had rang them. And he suggested I could be a drug distributor, a drug mule or whatever. No reason was given by the police as to why he suspected me of such. And I suppose I should tell you, I'm going in my late 70s now, but I'm going a few years. So I was in my 70s, and it was about 3-4 years ago. So I was, 72, something like that. And I was well dressed in a conservative suit, a white shirt, a blue tie with pocket handkerchief, black shoes. So I'm not looking like a ruffian or your typical idea of what a drug dealer on the streets would look like. The police said I was suspicious, which backed up his accusation because I'd failed to stop when asked to do so and I'd run from them. Now, I wasn't aware that anybody had told me to stop. I'm going along. I'd seen the police. I'd parked my car and I was walking across the road, and the road's quite a busy road. So I looked at the traffic, got a space, boom, 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 and I trotted across the road. But run from them, and no one said, because the car park was quite large. It's a housing estate now, but it was a large car park with several houses now. But in the time, And so they were one end of the car park, I was the other end of the car park. I never heard them if they shouted or anything, I don't know. But anyway, as I say, I was told I'd run from them. Now, as I said before, I was in my 70s at the time. I was on my second replacement hip. My left hip was smashed in an accident, and I had it replaced. It went wrong. I had a lot of trouble with it, and I had it taken out. And I had a second replacement hip, and in the consequences, I suffered a major heart attack, which scarred and killed 67% of the left ventricle of my heart. And that's the part of the organ of the heart that pumps the blood around your body. So it means lack of blood, lack of oxygen around the body. So it's impossible for me to run. Now, I must admit, I was messing about with the police. I knew I hadn't done anything, and I knew they couldn't get me on anything, and I knew I could charge them for assault and false detainment, false arrest, because, and I'll explain that in a few moments. But so I played with them a bit for their false imprisonment, and the secondary charge, of course, of assault and battery, the pushing against, the shoving against the wall, the bashing of my elbow, and the holding of my arm. Putting a hand on a person is assault, and police person can do that, but not if you've done nothing wrong. So there was 2 charges I could have made against them, and I could have claimed compensation, but I didn't. I was having a lot of fun. So what does, I said I'd explain, what does a false arrest look like? False detainment look like? A false imprisonment is the complete deprivation. Now I'm reading this off, this bit. False imprisonment is the complete deprivation of liberty for any time, however short, without lawful cause. And that was, you can see, if you wanted to look it up, it's Clark and Linsell on Tort's 19th edition, 2006. Look at 1523. It's also known as wrongful arrest, unlawful arrest, false arrest, and innocent victims of police misconduct can claim compensation for false imprisonment as a head claim. Head claim, technical word, although head isn't technical, but it is in law. And false imprisonment or false detainment is a head claim, but also head claims are assault and battery. So I had 2 head claims if I'd have wanted to. Malicious prosecution, well, it didn't get that far. Misfeasance in public office, wrongful working and behaviour in public office. Yes, but because the assault was misfeasance in a public office, but let it go. Trespass and negligence. Trespass if the police come on your property without a warrant card. And negligence. You have an accident because of their negligent handling of you. Now, the law on civil actions against the police. So if I'd have wanted to sue them, for full details on how the law defines these claims, the legal requirements prove that the claimant must prove, so I would have been the claimant, I have to prove that they detained me and there was no lawful authority to justify the detention. The claimant must simply prove that they were imprisoned, detained. But once he or she has done this, the onus then lies on the defendant, the police, to prove they were justified in doing so. This is a settled law dating back to 1881, in the case of Hicks and Faulkner, and means that the burden of proof is shifted into the false imprisonment claim. So every imprisonment is prima facie, on the face, unlawful. Every detainment, every imprisonment is unlawful. This is stated in Liversidge versus Anderson, 1942. So again, it's well established in law. How do you prove the detention in false imprisonment cases? Detention can occur in many common situations, such as in the course of stop and search, during questioning, on arrest, in prison. So it's got to be one. Stop. You've been stopped. You stopped to be questioned. You've been arrested. You've been put in prison or in a police cell. The place of where you're detained is irrelevant. So, for example, it could be in your car. It could be in their car, in the police car, in your own home, or in the street. But it must be total. Now, I'll explain that as well. Now, in my case, they tried to get me into the back of their police car. First of all, I was in the street, and when I said no, unless I've been arrested, why would I want to get in the back of a police car? And the policeman, remember, it was a policewoman and a policeman. The policeman said, "Well, it must be embarrassing for you being interviewed by two police in the street outside a shop." And I said, "No, it would be more embarrassing for the shoppers to see me in the back of a police car." But after about 10 minutes, 15 minutes, I said, "I'll get in the back of your car." And I got back in the back of the car, and they said, "Right, what's your name? What's your date of birth?" And I said, "I will give you my name and my address. But I'm not going to tell you my date of birth because I didn't want to let on how old I was." And I did, and they got on the radio, and it comes back, there's nothing on him. And I said, "I know. Now that you know that, I'll empty my pockets." And I emptied my pockets on the seat and the back seat, and I turned my pockets out, sort of pulled them out so they could see the whites of my pockets, inside of my pockets, and to see. And he said, "Okay, sir, you may go." And I said, "No, I can't." And they said, "Why not?" And I said, "Because I'm in the back of a police car, and you can't get out of the back of a police car. You've got to get out the car and allow me out." And when the police officer did, the male, he opened the door for me. I said, "Thank you, sir. Well done. You can go now." And I treated him as if he'd been my chauffeur. I was having fun. But I know it was a bit cheeky. But, at my age, okay. So the place of detention is irrelevant, as I say. The means used for detention need not be physical. And that was the way back. That was decided in courts by Bird versus Jones in 1845. An assertion of authority, for example, "You're under arrest," is enough. Or, in their case, you're detained. Detention short of actual arrest may constructively amount to a complete deprivation of liberty. For example, where you're told or led to believe, because they didn't tell me I was detained and they didn't say I was arrested. So detention is short of actual arrest may constructively amount to a complete deprivation of liberty. For example, where you're told or led to believe that you're obliged to remain to assist the police. And that was established by Warner and Ridford in 1858. These laws go back so far, but they're useful to know, and I did. So it was a case of having fun with them. Okay, I'm getting full of myself here, aren't I? There's no minimum period of detention for a claim to succeed, although the length of detention has a bearing on the level of compensation. So the longer you're detained, the more compensation you get. So I was there for about half an hour with the police. I did maintain it, and I did play with the idea in the back of my head, so that's half an hour. That's worth about £10,000, but I didn't progress it. I thought I've had enough fun. But forced imprisonment is actionable in itself. This means that the claimant does not need to have suffered any damage or be aware of the forced imprisonment. They don't have to be aware, although damages in such case will be nominal. Murray versus Ministry of Defence, 1998. So we're coming closer now. This also applies to cases where, on balance of probabilities, the claimant would have been detained if lawful policy and procedure had been followed. Lawful authority in wrongful arrest claims. Once the claimant proves that they have been detained, the burden of proof shifts to the police to establish it was lawful. for the detention. Now, they wouldn't have been able to prove it was lawful because the accusation was from a car park warden who had not seen anything. Why he picked me out, I do not know at all. And they wouldn't tell me. Once I was proving myself innocent, they wouldn't go any further into what he'd said to them. I could have asked for Freedom of Information Act and found out, but whether they recorded it or not, I don't know. The arresting officer, okay, Section 24 and 28 of the Criminal Evidence Act, PACE, police call it PACE, Police and Criminal Evidence Act, it's 1984, shows that the following conditions for a lawful arrest without warrant are necessary. The following conditions are necessary. The arresting officer honestly suspects that the arrested person was involved in the commission of a criminal offence. That's a subjective test. Now, there is an objective test. The arresting officer held that the suspicion was reasonable on reasonable grounds. That's objective. So the first is subjective. He honestly suspected the arrested person had been involved in committing a crime, and the arresting officer for objective is he held the suspicion on reasonable grounds. Now, you see, one is he could be a drug pusher. Go and detain him and question him. That is not an objective test. The suspicion of reasonable grounds would be to be seen with other drug pushers and seeing something underhand going on, you know. Now, the arresting officer's reasons for effecting an arrest amount to a reasonable belief that the arrest was necessary, usually to allow the prompt and effective investigation of the offence or the conduct of the person in question. That's the necessity test. These are important tests: subjective, objective and necessity. The officer informed the arrested person of the facts. They've got to do this. The officer informs the arrested person of the facts of the arrest, the grounds for the arrest, as soon as reasonably practical, and that's in section 28 of PACE. The arresting officer exercise of his or her discretion to arrest was reasonable in public law terms because PACE confers discretion, not a duty of arrest. It's called the Wensbury test. Honest suspicion, reasonable suspicion, both the subjective and the objective test must be considered when assessing the suspicion. For honest suspicion, the court will consider whether the arresting officer honestly suspected in his or her mind at the time of the arrest the person arrested was involved in the commission of an offence. This is a subjective test. What is a suspicion of in unlawful cases? Again, when I was arrested, the idea of a subjective test that the arrested person involved in the commission of offence, no offence was seen, no commission of offence was seen, and there should have been no suspicion in the mind. Lord Devlin. Now, most of us have heard of Lord Devlin, a very famous law judge. He said, suspicion in an unlawful arrest case. Suspicion in an ordinary meaning is a state of conjecture or surmise where proof is lacking. I suspect, but I cannot prove, would be the Shaban bin Hussein versus Chong Fook Kam 1970. A simpler definition is that the reasonable suspicion is more than an hunch, but less than proof. Whether the suspicion is reasonable would depend on the assessment of what information was in the mind of the arresting officer at the time of arrest. So when I was stopped, and I wasn't arrested, but I was detained, what was the reason? The suspicion has got to be reasonable. And this is an objective test outlined by O'Hara versus Chief Constable of the Bar Ulster Constabulary in 1996. Lord Justice Hughes expanded on these definitions in Buckley and others, versus Chief Officer of Thames Valley Police in 2009, when he said, "Suspicion is a state of mind well short of belief, and even further short of belief in guilt, or that guilt can be proved. Suspicion falls well short of belief and even further short of belief in guilt, or that guilt can be proven." He said in Buckley, the case of Buckley, an arresting officer may rely on what he has been told by others, who may be civilians, civilian informants, reliable or unreliable, or other officers, providing the information thus assembled provides reasonable grounds for suspicion. In my case, what was this car park attendant or car park warden? He came to collect the money out of the machines, I believe. He did have a bag, so I think, who knows. But what was the reasonable grounds for suspicion? I parked my car. I went over the road. I came back, put some goods in the back of my car, which I'd bought from the shop across the road, and then I left the car again when he pointed me out. What had I done? I parked my car and put my groceries in the back of the car. In my case, as I had not been selling drugs, and I'd not been seen selling drugs, or handling drugs, or speaking with any other person, because I didn't, the suspicions were not backed up by any evidence, and therefore did not provide for that information thus assembled, providing reasonable grounds for suspicion. There was none. So it's irrelevant if the arrested person actually committed the offence. A police officer can completely mistaken, i.e. relying on mistaken identification given by the witness, and the arrest can still be lawful. The issue may be whether the officer's reliance on that identification was reasonable. In my case, it wouldn't have been. What happens to suspicion when the subject provides an explanation? So, if they stop someone, detain them, arrest them, and the police suspicion is then the suspect who's been detained provides an explanation. If, when challenged by police, the suspect provides an explanation, then the officer should take this into account in deciding whether their initial suspicion can be maintained or remains. Can the suspicion be maintained? Does the suspicion remain? Based on reasonable grounds. And that was Buckley versus Thames Valley Police. I mentioned Buckley earlier. This is an essential relevant. It's especially relevant in police warrant claims, where, for example, a wrongfully issued arrest warrant can be easily explained and quickly checked by the police. Should I go on with more? I've got more, but I don't know whether I'm boring you now. Yeah, I'll do a little bit more. What happens if the suspicion of the suspect provides an explanation? When, if challenged by police, the suspect provides an explanation, then the officer should take this into account, deciding whether their initial suspicion can be maintained. The test is, this is for arrest, the test is whether the police officer actually believed that the arrest was necessary, and that it was necessary for a Section 24 and Chapter 5 in PACE, police, as I said before, a reason, and that objectively that belief was reasonable. Usually the police rely on Section 24(5)(e) of PACE, and this states that an arrest is necessary to allow the prompt and effective investigation of an offence. In my case, there wasn't an offence. But that didn't stop that PCSO throwing me into the wall and grabbing my arm. He could have been subject to discipline, maybe even dismissal, and that's why I didn't progress it. Hopefully he learned, and those police officers who said run, go away, that they would talk to him and say, what did you do? What was you doing? Hopefully they did, because I played them up so much and won so much in their car that I'm thinking, whoa, we don't do this again, and they'll talk to him about it as well. Hopefully, we can but hope, can't we, that the police do learn from their interactions with the public. So I'm going to leave it there, I think. I don't think I need to say any more. I have got more, but I think I'm going to leave it there. But I hope this helps, because you may not think it was useful to you, but neither did I. But I learnt this because I used to teach, I used to lecture in colleges and various courses, health and safety, security courses and police courses and psychology. I taught a lot of courses, but I learnt this and it helped me when I was stopped. But I never expected to be stopped in my 70s, well dressed, doing my shopping, and being attacked by a police community support officer and then detained by 2 police officers in my time of life. So you don't know. And so you probably won't remember all this. I've spoken for a long time. But think, if you do get stopped, and people are being stopped now for standing in streets, being stopped for silent prayer, for being stopped because they've got a notice saying, here to speak if you wish. There's been lots of people. People have been had police on their door because they've done a post that someone complained about. And so it could happen to you. And you won't remember this, but you'll remember you do not have to speak to the police. You can stay quiet, and they'll say, if they're arresting you, they'll say, you have the right to remain silent. Believe them, because when you speak to the police, they do twist what you've said, and they say, why are you nervous? Why are you shaking? Are you ill? Do you need a doctor? And it's all, and they surround you as well. Even if there's only 2 of them, one will face you, but one will start walking behind you. It's intimidation tactics. They're taught it in police college. And you need to realise this, and you need to understand this. And you have the right to stay quiet until you have a solicitor. And they have to provide you with a solicitor free of charge. So, make use of it. Don't allow them to intimidate you and browbeat you, because they will, because they're trained to do so. So I'm going to finish now. It's coming up 28 minutes. It's just gone past 28 minutes. I'm going to leave it there. Until the next one, be safe, be good, and bye from DJ. Bye for now. Bye.